Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. Most estate planning attorneys can easily give you a long list of reasons why you should have a will, a trust, or an estate plan. But is legal planning right for everyone? If you've been wondering whether or not an estate plan would be a helpful tool for you or your family, this webinar Wednesday is for you. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also note that if you have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. Note that all three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. We're going to get right started. This is actually kind of a fun one here. So the 8 reasons you shouldn't do an estate plan. So some of this is a little tongue-in-cheek here, but we're going to actually cover some really important points that a lot of people really don't think about. So a lot of this is going to be a little bit tongue-in-cheek, so we're kind of reversing it. But the first one I came up with was that you'd like to make it as difficult as possible for your family. And I know that sounds funny, but the reality is, and this is interesting because I've just had lots of people in my office this last week or two that have been telling me stories about how they were the executor or the person that had to settle the estate for their parents and all of the troubles that were caused as a result of it. Or sometimes it's the lack of planning. So people think that they want to make it simpler, and so they say, well, we're going to make it simpler by just putting kids' names on accounts, or just having it go through a will, or adding a kid's name to a deed. And I'm here to tell you that most of the time that's just going to cause much more of a headache, many more problems, sometimes more taxes, often a great deal of difficulty for the family in dealing with that. Not planning at all certainly is often going to cause family arguments, make it more difficult, make it where they have to go through probate. A lot of people think, oh, if I just have a simple will, that's going to keep me out of probate, right? No, that's actually going to guarantee you're going to go to probate. So a simple will is going to make sure that you go through probate. A will is just directions to the probate court. And so certainly if you don't do any planning, some people think, oh, well, I've got my daughter's name on my account, so that's good enough. No, it's not good enough. In fact, what that means is you're exposing your money to any problems that your daughter has. You're not planning for what happens tomorrow. You're only planning for if everything stays exactly the way it is today. And so often, this is just something that's come up quite a bit in the last couple of days, where we've had folks come in and they've told me all the horror stories about trying to settle their parents' estate. And it's caused them all kinds of difficulty because their parents hadn't planned sufficiently, didn't have a thorough and well-rounded holistic estate plan. We had somebody recently that we were trying to help and are still trying to help, that their parents, the kids thought, oh, well, dad has been so great through the years. He's done really well with his money. He's invested and all of these things. In fact, dad was so good at it, he didn't have a financial advisor. And so he had all these different accounts he had probably 8 or 10 different investment accounts, which none of them were with a financial advisor. He would just deal directly with the companies on all of these. And so now when dad is sick or when dad passes away, we have to deal with each of those companies without having any contact person. And it's gone on for months and months and months just trying to get somebody to talk to at one of those companies to be able to deal with these assets. And it's caused all kinds of family arguments. It's caused all kinds of grief. It's caused all kinds of attorney fees because they're paying us to assist them with this because dad thought he was doing great because he invested his money, he saved money, but he didn't have any central management of that. We even had powers of attorney. But it still meant having to go through each company, and each company had its own rules, as opposed to having a plan where we just say, okay, we know exactly what's going to happen. We have the authority to act. We have the authority to settle the estate. We have the authority to act in the event that dad becomes sick or has dementia or those types of things. So the family had been real impressed with how dad had handled things. But the reality was it wasn't good, because when dad wasn't able to handle it anymore, we had to go to these 800 numbers for the 8 to 10 different companies, and each of those companies had all these different rules about how to manage that account and how to access that account. And it's gone on for months and months and months, and caused all kinds of aggravation and legal fees and back and forth. And if dad had a thorough estate plan where everything was situated in the trust, we had the trust set up properly, we had the estate plan done properly, it would have avoided all of that, avoided all of those problems. So that is a very important element there. All right, so my next one, and again, we're a little bit tongue-in-cheek on all of these, is that you really like the idea of letting a judge decide who is going to make decisions for you if you get sick or have dementia. So not having a plan in place, not doing an estate plan, a lot of people think that they're just doing an estate plan or doing a will to talk about what happens when they die. I think it's just as important because of what happens if you don't die, meaning there comes a point in your life where somebody else needs to help you pay your bills or needs to be able to organize things or balance your checkbook or whatever it is, whether it's for convenience or because of dementia or because of illness or a stroke, anything that might happen. And the bottom line is, if we don't have an estate plan in place, you're basically saying, yeah, I'd prefer to have the judge decide that. This is a big controversy in Michigan right now, and I'm going to talk a little bit about this a bit later. But so the law implies that the family would have the first option. The judge should appoint family members to make decisions. But what's happened over the years is that in many cases, the judge appoints a stranger, appoints a company. There were some guardianship companies out there that had thousands of people that they were guardian for, and there's been some really horror stories. So are you okay having the judge make that decision? I had a family I was helping years ago, and in this particular family, the person that they were that needed the help was a sister, and so the sister couldn't make her decisions anymore. And so she hadn't done planning, even though she had quite a bit of money. So let's just say unlimited amount of money, millions and millions of dollars. And so what the family wanted to do, because she had millions of dollars, they wanted to make sure she had the best care. So they were paying for 2 different caregivers to be with her around the clock, just a team of caregivers that would be able to help her live out the rest of her life and make sure that, because they had the money, why wouldn't they do that? So they were paying caregivers, and they were actually paying caregivers more than the going rate because they wanted specific caregivers. They wanted to make sure it was this situation and that they showed up on time and they didn't have just random people showing up. It was the same people. And so they were paying over market value for these caregivers to be with their sister 24 hours a day to take care of her. And since she had the money to do it, you would think that would be okay. Well, because she didn't have her estate plan in order, this ended up having to go before a judge. And so at one point, someone objected and said, well, we think that we're spending too much on caring for this person. And the judge agreed. And the judge said, well, no, you can't have those caregivers anymore because you're paying a few dollars more per hour than you would pay for this other company that's offering it. And they said, well, judge, it's her money. It's not our money, it's her money. And we believe this is what she would have wanted. We want to pay, you know, a little higher for the caregivers because of the unique situation, because we have the money. And the judge said, no, you can't do it. The judge prevented the family from spending money to provide care for their sister. That was the sister's money. It was her money. And the judge said, no, you have to pay market rate. You have to pay going rate. And because this other company is willing to do it cheaper, you got to find a company, or you got to find caregivers that are willing to pay, accept a lower hourly rate. And that's the type of a thing that the judge, I guess, can do in a situation. And our goal is to say, well, maybe, you know, if you have a plan in place, we don't even get in front of the judge. We don't leave those decisions or discretion to the judge. So if you really like the idea of letting the judge decide who's going to make decisions for you if you get sick or have dementia, that's a good reason not to have an estate plan. Again, you get that this is all kind of tongue in cheek. All right, so the next one I came up with here is you like paying more in taxes because you believe that the government is better at deciding how to spend your money than you or your family would be. So what am I talking about here? So a lot of people say, oh, well, you know, we're just going to keep it simple. We're going to put beneficiary designations on things. And one of the results of that is often that Uncle Sam's going to take more of the money. This is particularly true as it relates to retirement accounts, IRAs or other retirement accounts. So most retirement accounts, other than Roths, you have not paid the taxes when you put the money into it. That did not count as income in those years that you earned that money because it went into a retirement account with the idea that you would pay the taxes later. Well, often if we don't have the plan set up properly, Uncle Sam's going to get a much larger portion of that money than if we had the plan set up properly to be able to stretch out those payments after your death. Another thing that came up, is coming up recently, is there's some proposals that they're going to change the estate tax or death tax laws, particularly as it relates to estate tax and as it relates to capital gains taxes, or something called step up in basis. If they change those laws with regard to step up in basis, it's going to make a big difference, and planning is going to make it so that we pay less taxes, capital gains taxes, income taxes. Even without that, one of the things that people will do, they say, well, I don't need an estate plan because what I'm going to do is I'm going to transfer my house, I'm going to transfer the farm, I'm going to transfer this business to the kids while I'm alive. Well, what does that do? So let's say mom and dad are farmers, they own 100 acres, and they say, well, we're getting older, we're going to avoid having to do an estate plan, and we're going to avoid having to do a will or a trust because we're just going to gift that land to our kids while we're still alive. What does that mean? Well, it means that the kids, when they go to eventually sell that farmland, are going to pay capital gains taxes on it that they wouldn't have had to pay had we done an estate plan. And that's accurate because the idea is capital gains taxes, capital gains, anything that appreciates in value. So if mom and dad bought the farm in 1950 for $40,000 and now it's worth $700,000, there's a whole lot of gain between that $40,000 and the $700,000. Now, the IRS has the right to tax that as a capital gain, except for certain exemptions. If it's mom and dad's residence, they're going to get an exemption for that. They're going to get where they don't have to pay capital gains and taxes on it. But it's not the kid's residence. So if we gift it to the kids and the kids sell it, then they're going to have to pay capital gains. If the kids inherit that farm and they inherit the $700,000, they inherit it, it cleans the slate. They have what's called step up in basis. And so now they receive it at $700,000. If they then go to sell it at $700,000, there's no gain because their tax basis, or what they acquired it at, is $700,000. Here's the problem. If you gift it, you don't get that step up. If you gift it and say, okay, I'm going to avoid having to go to court. This is great. We're going to solve all these problems. We're just going to gift the farmland to the kids during lifetime. What does that mean now? Well, it means that when we gift something, they also get your purchase price or your tax basis for it. So now they get it at $40,000, and when they go to sell it at $700,000 or whatever it is at a future date, they're going to pay a huge tax that they would have had to pay zero tax if we had done it right. So it seems like a great idea, right? Where mom and dad are getting up into their 90s, why not just avoid having to go through probate, avoid having to go to a lawyer? We're just going to get this form that we found at the county office, sign it over to the kids, and we're all set. A lot of farmers actually do this. And what's it going to cost the kids? Hundreds of thousands of dollars in taxes that they could have avoided. In other words, they're probably going to have to sell the farm just to pay the taxes, right? Okay, so that's another reason why you might want to have a estate plan if you just want to give more money to Uncle Sam. You love family fights. It's entertaining to you to see your kids fight. This is another thing that I've seen recently is when it's not planned out properly, when we don't have proper protections and permissions in place, it's much, much more likely that people are going to fight about it. I actually think it's going to be much more likely if it goes through probate. So one of the things that we try to do for folks is to keep them out of the probate process. Why? Because I think the probate process in and of itself often causes family fights. Here's why. If it goes through probate, there's all of these letters and forms and documents that we're required to send to the family, but it doesn't actually say anything. The documents, so every few weeks they're getting these documents in the mail. It has all of these required disclosures, but none of it is actually anything that they're interested in. And it just starts to get frustrating. You're saying, I don't know what's going on. I don't know why this is taking so long. I don't know, my brother's the executor and I don't know why he's taking so long, why it's going on for this long. And I keep getting these stupid pieces of mail that don't say anything, and it's just getting me more and more frustrated. And I've had this years and years now. We have calls coming up from people saying, I'm pretty sure my brother's messing this up because it's been 6 months, we haven't settled the estate, and I just keep getting all of these pieces of paper in the mail coming to me, and nobody's telling me what's going on. You just defined probate. That's what the probate process looks like. And so it's very likely that the brother's not doing anything wrong, but they are following the rules. And I think it actually often causes family fights. All right, what's the next one? So my next one is you're okay with a stranger making decisions for you. And I actually have a specific example on this. So this is a case in Michigan where a daughter and stepdaughter, so it was a husband and wife, it was a second marriage for them. So the family got together, they realized that the husband and wife were not able to manage things for themselves. So the daughter of one of them and the stepdaughter of the other petitioned the court to be appointed to be able to make decisions for them. Instead of the judge awarding that authority to the daughter, they picked a guardianship company called Caring Hearts. Well, Caring Hearts proceeded to spend about $400,000 over 6 months of the people's money in caring for them. Well, it shouldn't cost $400,000. Well, why did it cost $400,000? Well, Caring Hearts decided that the person that owned Caring Hearts hired her company that she owned to provide the 24-hour care. She also hired her husband, who was an attorney, to provide legal services. And over that period of time, she spent $400,000 in 6 months to pay her other companies and her husband for their services. Well, it shouldn't cost anywhere near that amount of money. And the family was upset about this. And they were saying, well, why weren't we appointed? Why wasn't the daughter appointed when she asked to be appointed? And the judge wouldn't let the daughter be appointed. And she kept asking questions and going and visiting her mom and dad or her mom and stepdad. And after a while, the guardianship company didn't like that the daughter was visiting because she actually lived right next door. So they put up this fence. They put up this privacy fence. And this is actually the gentleman that was the person who was needed a guardian. He was the dad, and he was trying to talk to his daughter or his stepdaughter through the fence because the guardianship company put up a privacy fence all the way around their house, so he couldn't talk to his daughter. So his daughter couldn't come visit him whenever he wants. So they couldn't visit, and then they put restrictions on how often the daughter could come over and visit. and they said, okay, no, you can't just come over anytime you want, and they put up a privacy fence so that he couldn't even communicate with his stepdaughter, or you know. And so, isn't this crazy? This is such a crazy scenario, but this is real life. This is actually what happened. Now, it was abuse. The guardianship company was removed. The judge was removed from the case. There, you know, this isn't what it's supposed to happen, but this is what can happen when you appoint a stranger to be in charge of your stuff. All right, my next one is that again, all of these are kind of tongue-in-cheek. You'd rather have your son-in-law or daughter-in-law get money instead of your child. So you leave money to your child, the child gets divorced, what happens to your inheritance? There's a good chance that without planning, that half of the inheritance that was supposed to go to your daughter or son is now to their divorced spouse, that they get it in a divorce, or, you know, there's any number of scenarios like that. Can we make sure that that if you leave money to your kids, it's not going to be lost in a divorce, not going to be lost to lawsuits, not going to be lost to creditors? Absolutely, that's part of the planning that we do. But if you'd rather have it be exposed, then that's, you know, that's a good reason not to do estate planning. I like this one. You like to gamble, but not only do you like to gamble with everything you have, your life savings, and leave it to chance. So let me give you an example of leaving it to chance. And I see so many people who have done this. They say, well, it's a second marriage and you got his kids and her kids and second marriage. And so they say, well, I'm going to leave everything to my spouse. They've been married for 30 years, even though it's a second marriage. That kind of makes sense. But then what we're doing is we're throwing the dice and saying, okay, well, whoever lives longest, their family is going to get the inheritance. So we're throwing the dice. We're taking our chances, and the one that lives longest wins because their family gets the inheritance, and we completely cut out the other family. Is that what mom and dad had intended? Probably not. Is it because of the wicked stepmother? You know, that whole thing about the wicked stepmother in Disney movies and all of that? Well, it probably came about from people not getting an inheritance because dad dies, leave everything to his spouse. Spouse dies, everything goes to their family, and dad's kids get cut out completely. Does that happen? Every single day. Can it be avoided? Very easily with just doing some estate planning. But if you say, you know what, I'm just going to roll the dice, and if I live longer, my kids are going to get everything, and if my spouse lives longer, their kids are going to get everything. You want to roll the dice that way, or you want to do an estate plan? So yeah, if you're okay rolling the dice and gambling with everything, then that's a good idea, just not to do an estate plan. All right, I think this might be the last one. You like your money going to lawyers and court costs, right? And that's exactly what happened. So I got a story. This is so funny to me. I heard a commercial. I haven't heard this in a while, but there's this company that does online wills, LegalZoom or something like that. And so you can buy your will online. So guess who one of the people is that bought their will online and didn't go to an attorney? It was Sammy Davis Jr. So if you remember Sammy Davis Jr., very popular entertainer from the 50s and before, and Sammy Davis Jr. made a lot of money, right? And so the advertisement, which just cracked me up because they were bragging and they were saying, well, Sammy Davis Jr. got his will from LegalZoom, and the judge ruled that it was a valid will. And I'm like, I'm sure the judge did. So what do we know about that? We know it had to go to a judge, that we had to go all the probate costs. We had to pay inventory fees for the probate. We had lawyers on both sides that fought about it for how many ever years, because it was several years after Sammy Davis Jr.'s death that they were making this claim that the judge finally ruled that it was a valid will. So how many thousands or hundreds of thousands of dollars went to legal fees and court costs and fighting over how many ever years for the judge to rule that it was a valid will? And I was like, all right, that's something to be proud of, that a judge finally ruled that this will that he got online, he could have saved so much money just going to a lawyer. But you know, Sammy Davis Jr., and this happens to so many celebrities. It seems like every time a celebrity dies, we find out that they didn't really do very good estate planning. Such a shame, such a shame. Aretha Franklin was one of the ones that died recently, and we heard that first of all, basically there were 4 or 5 wills that people came forward with and said, no, this is the accurate one, no, this is the accurate will. Well, that's bad estate planning. That's bad estate planning, because you shouldn't. We should have a comprehensive plan. and so they're still fighting about Aretha Franklin's estate. And so this happens so often with celebrities that if they would have just paid a little bit of money for a lawyer and had a plan, but if you prefer your money to go to lawyers and court costs, then it's a good idea not to have an estate plan. So yeah, so we were having a little fun today, obviously, saying why you shouldn't have an estate plan and just being a little tongue-in-cheek and playing around with this. But there is some good points here about saying, well, all of these things are the bad things of why not having estate planning is going to cause you all kinds of trouble. And I think it was worthwhile going through those because I do hear this all the time. Mom and dad think they're going to be fine. We're going to be fine. We don't need anything. We don't need to go to a lawyer. We're not willing to do that. My grandparents didn't, this is what they say. My parents didn't have a lawyer and everything was fine. Okay, well, it probably wasn't fine. And nowadays things have changed quite a bit with regard to the law and everything else that could happen. So you're really taking your chances if you don't do a estate plan. So I hope you enjoyed this. This was just kind of another, another way of thinking about things, and we're just being a little silly today. But I hope you enjoyed it. So if you do have any questions or if you'd like more information about any of the things that we talked about, Savannah's going to come on in a second here, and she's going to give you instructions how to get further information from us or how to get your questions answered.
Thanks, Bob, and thanks for everyone else for joining us today. As Bob mentioned, we do have a couple of easy ways for you to get in touch with us if you have questions or concerns, or you just want to get more information, or maybe just get to know us. We're here. You can always give us a call. Our phone number is 1-800-990-6030. Again, that's 1-800-990-6030. Also in the chat, I have put a link. It will take you to Calendly, which is just a scheduling program. You can choose the day and time that you would like our team to give you a call. So maybe you're on the road right now, or you might be at work, or who knows, but we can schedule a time to give you a call at a time that's convenient. So again, that link is in the chat. I'm also sending an email. You may have already gotten the email, but the email will also have our phone number, this link that you can schedule the day and time for us to call you. Or, you could always just respond to the email and we can take care of you that way and start the conversation. So either way, we're looking forward to getting in touch with you, and we are here to help. Thank you so much. I hope you enjoyed this webinar. We will see you next week.